Child Circle is a small centre of expertise, a small organisation which is Brussels-based and focuses on EU child protection policies. And of course, a key area of EU policy that's relevant to child protection is asylum, migration and trafficking. But I'll be happy to give you more context later. We have heard from the report about the realities of disappearances and responding to disappearances. And of course, this session is meant to deal with the legal obligations and how they apply. And that sounds like a much more abstract issue. But this session is going to try not to deal with theory alone. The partners' overall goal in this training and in the elusive handbook, which will arrive, was to be very practical, including in the section on legal principles. And there are a wide range of laws that can be relevant to disappearances. And our aim was to bring them together into a set of guiding principles. So in this session together, we're going to examine each of the principles and see how they're linked to specific EU provisions. Now, one thing we need to really think about as well is there are new EU measures under development in light of the high number of children arriving. And we really should think about that and also take the opportunity this afternoon to raise questions and to float ideas with the panel of policymakers. It's a vital time to try and achieve some change. So just an introduction, if I may. What do we mean by guiding principles? I mean, at one level, the fundamental legal obligation for states is very straightforward. When children are deprived of their parents, the state has an obligation to provide special protection and assistance to them and ensure their safety. And clearly this involves the obligation to prevent disappearances and properly respond to disappearances. But it's evident from everything that we've just heard that preventing and responding to disappearances, in particular of unaccompanied children from third countries, is a very complex and technical and sensitive task. Now, this is partly the case because of the diverse reasons for which a child might disappear. Do they want to go to another country? Do they want to join family in another country? Have they been lured by individuals who will exploit them? It's also complex because measures to respond and prevent disappearances relies on effective cooperation between a wide range of actors who have very different responsibilities. That they include the reception centre staff, the guardians, the social service, law enforcement, hotlines, migration officials. So if we are to have guiding principles, they need to take account of the specific challenges associated with both this group of children, namely unaccompanied children, and the different actors that work with them. So it sometimes seems that the fact that cases in this sector are so difficult to investigate is treated as an excuse for not responding at all. But in fact, it means that we need to put in place tailored procedures and specific safeguards. So let's think about that. Equally, the fact that there are so many different actors involved demands that we establish a simple framework to create common understandings of the basics. There can't be good cooperation without common understandings of even the most basic elements. So in a nutshell, the basics can be put fairly simply, and these are underlying the principles as we state them. First, we have to take responsibility for what happens to unaccompanied children in our territory. We'll come back to what our territory means. Does it mean our country or the EU as a whole? Secondly, we need obviously to actively try and prevent children from going missing. So that involves, as Federica says, establishing trust, engaging with the child, and offering proper protection and support so that fewer children run the risk of simply disappearing. Thirdly, we need to be very proactive in gathering information about the circumstances of the child. We need to ensure there's as solid a basis as possible to investigate disappearances. Again, it's been underlined. Fourth, we need to find ways to work effectively together and combine our different responsibilities and skills. And fifth, let's not stop at the borders. The children, as we know, often don't. So we need to work across the borders with the support of EU. Now, in a moment, we'll look at each of these principles and see what existing EU measures connect to them and can contribute to achieving them. But we also, I think we all recognise that we need to be very clear-sighted about the fact that additional EU measures are urgently needed to ensure that we can comply with these principles. We cannot resolve the underlying issues that push children into unsafe movement between member states or leave them prey to traffickers without better measures of solidarity between states and without a sense of common responsibility. So let's think about that as we go. Now, let's now look at the EU landscape. If I say EU, do you think I've gone back to dealing with the abstract rather than the real? Sometimes the EU can seem very remote from our daily work. So, as a starting point, let's be clear on how EU provisions can help us as practitioners, as advocates, as policymakers. Now, effectively, EU law is national law. We shouldn't forget that. National implementing measures and practices may be needed properly to fulfil certain obligations. But if those national measures don't fulfil the obligations, they can be challenged. So that means that knowing EU and international law can help you promote or build certain processes locally. So it's a tool for you. It's a tool for us. Now, equally, because there is a common legal framework, we can directly learn from the experience in other member states who are fulfilling similar obligations. So we can learn about how actors in other countries work together to resolve issues. And that's part of our workshops here today. There are also quite a few practical measures of support at EU level that can sometimes be hidden up on the shelf, but they are designed to be of direct relevance to practitioners. And I think, for example, of the Fundamental Rights Agency handbook on guardianship. The EU, of course, as we know, has a unique role, has a special role in establishing cross-border cooperation. So in short, EU measures do matter to our work. Very quickly, if I may, let's just take stock of the different bodies of law that are relevant. And again, just to make sure these are all very visible as bodies of law to you that can be drawn on. General child rights obligations are of central importance. These obviously include the UN Convention on the Rights of the Child, the European Convention on Human Rights, and the Charter of Fundamental Rights of the European Union. Clearly, again, international and EU asylum, migration and trafficking measures are directly applicable, and they set out common obligations concerning assistance and support of children. Now, there isn't anything specific, really. I mean, there are some small obligations about disappearances, but there aren't currently any specific provisions on registration systems or sharing of information beyond, for example, the SIS system of alerts that we'll come to. But let's think a little bit about that. It's not a non-problematic area, but obviously it would be very practically helpful. We have specific child protection provisions as well. They're clearly key. Some of them lie in the trafficking legislation. They provide obligations on risk assessments, ensuring actors have specialised skills, and sharing information. Anti-trafficking measures are also relevant to the criminal law enforcement side, as are EU data protection measures, which apply in sharing information, in investigations. Very relevant here. It can be a very practical stumbling block to prevent actors from cooperating with each other, but that's why it's key to find ways to handle and share sensitive data, and we'll hear more about that in workshops. Now, cross-border measures of different kinds have a clear bearing on disappearances. We've talked a little bit already about the Dublin III regulation. It allows for transfers of unaccompanied children to another country for the purpose of family reunification. And the changes that were brought about in the most recent regulation expanded the definition of family members and relatives. So the regulation could be a tool to prevent children from moving on their own from one country to another. But what have we seen? We've seen that the lengthy and complex procedures under Dublin, in fact, are contributing to disappearances. And we'll come back to the SIS border of alerts. Now, where can you find more information about these? It's an immense body of law, so we're not going to go into each of them. There is a reference document on EU law and policy that was developed in the context of the Connect project that some of you may be familiar with. And I really urge you to look at it. It sets out a compilation of the law and the policies, the practical work of the agencies, up to, I think, June 2014. So thankfully, there have been more things since then. But it does set out key obligations that exist. And there is a table in it which links the rights of the children and the specific provisions that might achieve those rights. So it's really quite practical. There's a second document that's important in the field, and it's the European Commission reflection paper on integrated child protection systems. Now, it describes an integrated child protection system as the way in which all duty bearers, namely the state authorities represented by law enforcement, judicial authorities, immigration authorities, social services, child protection agencies, etc. So we get the idea, everybody. And system components, namely the laws, policies, resources, procedures, etc. How they work together across sectors and agencies to form a protective and empowering environment for all children. Now, an integrated child protection system doesn't require explanation to an audience like this, but it was an important recognition at EU level of the idea of integrated child protection systems. And it set out 10 principles which provide guidance. And what's the practical significance of this? These principles are now influencing the way the EU works in a variety of different ways. So that, for example, in EU policy responses, very importantly, the recent communication from the Commission on the state of play of the EU agenda on migration notes that work is now underway to employ a comprehensive approach for the protection of children under the migration chain. So that whole notion of a comprehensive approach for protection derives from the thinking that was developed here, and many of you probably contributed to that recognition at EU level. I'm sure, again, the Commission in the panel later will talk about that. And the notion of guidance for child protection systems at EU level was, in fact, indicated in the EU anti-trafficking strategy. So specifically for trafficked children, it was there. We don't need little interventions. We need a protective environment. Legal obligations. Again, EU measures increasingly require actors working with children to receive special training. It'll be interesting to see. These provisions are currently being implemented. So it will be interesting to see how they're being implemented across the member states. What kind of training exists? Is it periodic? Is it regular training? Is it training that is joint across actors? Or is it by bodies of actors? And it will be a really good area to share information. EU research. The Fundamental Rights Agency recently did a mapping of national child protection systems. And this really helps us illustrate good practices and the common challenges we face. EU measures of support. I've mentioned the handbook by the Fundamental Rights Agency. The European Asylum Support Office obviously is also very involved in developing guidance, whether that's on age assessment. Currently they're looking at family tracing. They're also looking to provide guidance on the best interests principle and how it should be applied at hotspots. So let's come back to that. And also, these principles have influenced priorities in EU funding. The most recent call for funding talks about supporting multidisciplinary and interagency approaches to protecting children from violence. So these principles have a real impact and have the potential to have more of an impact if we all use them and refer to them. Now, in the next part, I just want to go back to each of the guiding principles and hopefully lay the scene mainly for our discussions on them. The first is, of course, very straightforward. An unaccompanied child from a third country is first and foremost a child. So that member states must ensure they benefit from all their rights as children without discrimination. Now, in the Connect project research and in the Missing Children conference last year, we talked about how the fact that it is a foreign child who has disappeared might colour our attitudes towards the situation. Does it affect our sense of responsibility for these children? A child who wasn't meant to be here is no longer here. Do we need to do something about that? But the fact that they are not citizen children, of course, in no way relieves the state of its responsibility to the child, as a child, first and foremost. And Article 24 of the Fundamental Rights Charter, very importantly, spends the time recognising these rights, that children have the right to such protection and care as is necessary for their well-being. It talks about the best interests as a primary consideration. And the Charter is, of course, binding on all of the EU institutions and the member states when they're implementing EU law. And the courts are getting very interested in how this should be applied in practice. So, I mean, clearly the fact that a child is from a third country may affect our sense of whether we can successfully prevent them from moving or find them if they do disappear. And this can vary from country to country, particularly, for example, a transit country may not feel they can successfully prevent a child who has landed specifically for the purpose of moving on. How can they prevent a child from moving? But of course, this reality only serves to emphasise the need to work very hard to guarantee high standards of reception and protection for these children across Europe. So the second principle, if I may, was that all responsible actors should fully respect the obligations of reception assistance and durable solutions. Engaging with the children and their situation should discourage children from taking matters in their own hands or surrendering themselves into the hands of those that would exploit them. And we've seen that there are a range of EU legal provisions which require member states to provide information and support and reception. But key questions to think about are, have children received enough support upon arrival? Has there been a guardian appointed? It's a very important step. Are children being given enough information? One example at EU level is the publication of a leaflet directed at unaccompanied children themselves. The Dublin regulation requires states to provide information to a child on Dublin. And the Commission prepared a leaflet, which I think we can look at and also call for its review to improve upon it. But there is that obligation to put the information in the hands of the children. Can children reunite with their families and relatives? We've talked about that. If procedures are too long and if they're insufficiently successful, children will move on. So we need to work on that. Are the special needs of children properly screened? The new EU asylum and trafficking provisions really focus attention on screening processes and providing tailored services as a result of screening the needs. And as Frederick said, screening provides an opportunity to identify risks of disappearances. Now, all of these measures can reduce the risk of disappearances, but clearly it is very difficult to remove the risk entirely. And more work needs to go into law and policy, in particular on establishing procedures for finding durable solutions. The third principle, thank you, is that basic information on the children's circumstances should be gathered and immediately available. And there are opportunities under EU law, or there are requirements, there are moments in the process where you gather information on children. One is registration at first encounter, and that includes at the new EU hotspots in Greece and Italy. Most of you will know that hotspots are intended to focus EU support in those countries to allow for swift identification, registration and fingerprinting of asylum seekers in Greece and Italy. Individual needs screening, I talked about, that's provided in the Reception Directive, the Asylum Reception Directive and the Anti-Trafficking Directive. And family tracing provisions exist. So the handbook obviously contains practical suggestions about how to gather that information, paying due attention to data protection and privacy. We know there are sensitivities to certain types of information. Should unaccompanied children be fingerprinted? What about the use of DNA? It'll be interesting to share experiences across countries. The Fundamental Rights Agency is currently carrying out a study on the use of biometric data in EU IT systems. And they are intending to look at both the positive and negative implications for fundamental rights. So we dance on that knife edge. We know that the information would be useful to have to trace the children, but we know the problems that it can cause on the other side. And again, at EU level, this is a moment where politically someone can say, let's fingerprint everybody, let's fingerprint all the children. And we really need to think about it because things can happen very quickly. Who handles the data? That's a sensitive issue. The fourth, we've talked about, the fourth principle, actors working together. We hear about this often. What in fact does it mean? I think Federica has already laid out very clearly the notion of joint protocols, joint training. And the Commission reflection paper principles specifically talk about the need for protocols and the training on identification of risks. So again, hopefully this seminar will stimulate some of the discussions we need. Finally, actors, the fifth is that actors should work together towards better cross-border cooperation. Again, it's worth noting that the Commission reflection paper specifically recognised that in view of the increasing prevalence of children in cross-border situations in need of child protection measures, efforts need to be stepped up on cross-border child protection measures. I mentioned the Schengen information system, the SIS alert on missing children. So a SIS alert will contain information to identify missing children. You can have pictures and you can add pictures and fingerprints if they are available. It can contain an instruction to place the child under protection if intercepted. And the Commission has recently implemented measures to ensure a better use of SIS, one hopes, including the fact that all the Sirena Bureau who get the alerts need to specifically say this child is an unaccompanied child who is missing. And that change came about from another EU-funded project on this issue, Vigile. So again, we need to think about what comes out of this project and how it can be used to affect change. My final words are on what's next at EU level. I don't want to anticipate the panel this afternoon, but maybe to give you some thoughts as you go into that panel. As I mentioned, the EASO is currently developing guidance on best interests of children. And the first point that they are developing guidance for is the hotspots. Comments, I think people can contribute to that process when they see it by giving comments which are effective. There is a new EU anti-trafficking policy framework expected next year. There will be consultations on the framework. As I said, the previous strategy specifically asked for EU-level child protection guidelines. It asked for models of transnational referral mechanisms. And frankly, the work on transnational referral mechanisms and even national referral mechanisms is still quite light, if I can put it that way. It's still under development. So I think it will have to be taken into the new policy framework. And the Commission is looking more generally at how they put in place this comprehensive approach for children in migration. The form of that remains to be seen, but that will be something the Commission will talk about later. So strengthening child protection systems needs to continue to be an integral part of the EU work and funding priorities. Sometimes this can look a bit like a luxury, or even by others, it can be viewed as a pull factor. Having a wonderful child protection system in Europe, some feel would be merely to put in place a magnet. But it is in fact a basic and essential safeguard, not only for the children who arrive, but let's keep it in mind for our whole society, but in particular for the children who arrive. Strengthening the connections between different national child protections is vital. Now, in the future, could we consider a European network of child protection agencies, or even a European agency which would have responsibility to deal with cross-border cases? I don't think we should exclude that possibility. But in the meantime, the guiding principles in the handbook are intended to ensure that we can work together to use the legal mechanisms we have in the best way we can. And where we can't fulfill these principles, this provides us with evidence of what needs to change. So using the principles should allow us better identify what can actually help children, rather than surrendering our responsibilities to them. So they were my final thoughts. Thank you.